This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why an insurer was properly sanctioned for failure to obey court orders, and why it is never proper to fail to comply with a court order because it's expensive to disobey a judge. Insurer Privilege Underwriters took its name too far, trying to obtain privileges from the Arkansas Court of Appeals to which it was not entitled, and acted contumaciously by disobeying the Circuit Court's discovery order. In Privilege Underwriters, Reciprocal Exchange versus Brendan Adams, a November 2024 decision of the Court of Appeals of Arkansas, the Circuit Court 1 granted appellee Brandon Adams' motion to enforce a court order and motion for sanctions and imposed a sanction fee in the amount of $5,000 against appellant Privilege Underwriters Reciprocal Exchange and awarded Adams $2,500 in attorney's fees and costs under Arkansas Rule of Civil Procedure 37. 2. Denied Privilege's motion for summary judgment, and 3. Denied Privilege's motion for protective order, which sought to bar Adams from taking any depositions. In an insurance coverage action in which Adams sued Privilege, his insurer, for failing to provide him a defense in a lawsuit filed against Adams and several other individuals and entities, Privilege answered Adams' coverage complaint, denying that it owed Adams a duty to defend the lawsuit and asserting a number of subject policies exclusions as affirmative defenses to coverage. Adams served written discovery on Privilege, and Privilege responded with objections and inadequate responses to Adams's discovery requests. Adams moved to compel Privilege to respond and produced documents, and the Court of Appeals ordered Privilege response and to pay Adams attorney's fees and costs in the amount of $2,000. Privilege produced its supplemental interrogatory answers and supplemental privilege log on March 2 of 2022, but did not comply with the Circuit Court's discovery order. Contrary to the court's order, Privilege refused to amend its privilege law, provide full and complete answers to Adams' interrogatories, or produce any witnesses for deposition, and instead, Privilege moved for summary judgment. Adams then filed his motion to enforce court order and motion for sanctions on April 25, 2022, and on December 20, 2022, the Circuit Court held a hearing on Adams's motion for sanctions and Privilege's motion for summary judgment and for protective order. The Circuit Court announced that it would sanction for its refusal and failure to comply with the Circuit Court's February 22 order. From the bench, the Circuit Court made specific findings that Privilege had failed to comply with the provisions of that order, Privilege to amend its privilege log to provide sufficient information to allow the Circuit Court and Adams to evaluate Privilege's claims of attorney-client privilege and work product protection, and to fully answer Adams's interrogatories. Generally, in order to establish contempt, there must be a willful disobedience of a valid order of court. Contempt is a matter between the court and the litigant, and not between the two opposing litigants. Before one can be held in contempt for violating the court's order, the order must be definite in its terms, clear as to what duties it imposes, and express in its commands. Contempt is divided into criminal contempt and civil contempt, and the standard of review on appeal depends on whether the contempt sanction was civil or criminal in nature. The Circuit Court imposed a fine and fees that were to be paid to Adams. A contempt fine for willful disobedience that is payable to the claimant is remedial and therefore constitutes a fine for civil contempt. Privilege refused to comply with a valid discovery order from the Circuit Court because Privilege disputed Adams's entitlement to the discovery underlying the order. Instead, Privilege moved for summary judgment, attempting to render moot the prior discovery order. The Circuit Court rightly held Privilege in contempt for its willful disobedience of the Circuit Court's February 22 discovery order and imposed a fine of $5,000. And once the February 22 discovery order was entered, Privilege was required to comply with that order, not question the propriety of that order or when Privilege should comply with it. The Circuit Court was unequivocal in finding at the December 22 hearing that it was sanctioning Privilege for its violation of the February 2022 discovery order. The Circuit Court then went on to explain that Privilege had disobeyed its February 2022 order by failing to provide contact information for the witnesses identified in response to interrogatory number 1, and by failing to provide a privilege log with sufficient information to allow the Circuit Court and Adams to evaluate the claim of attorney-client privilege and or work product protection. Thus, the Court of Appeals held that the Circuit Court did not clearly err in holding Privilege in contempt. The Circuit Court had ample authority to use its contempt powers to enforce its February 22 discovery order. In my opinion, this order must be more than embarrassing to Privilege and to the insurance industry. Parties in litigation are not entitled to refuse to fulfill an order of the court. Regardless of the name of the insurer, it had no special privileges and must fulfill the order to the letter and pay the sanctions, including the extra sanctions placed by the Court of Appeals. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. If you do, you'll receive notice of every blog posting, and we don't sell or distribute my mailing list. And you'll gain access to the more than 4,900 blog postings. You can also subscribe to these videos on rumble.com and youtube.com, and if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. Please tell your friends and colleagues about this blog and the videos so that they too can subscribe. And if you're interested in seeing further detail about insurance, insurance claims, insurance law, insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.